common. You want to make sure that all the intellectual property that's being developed by the founders, by any of the people working at the company, are going to be owned by the company. I can't tell you how many times we've gone into companies and we say, okay, where are these assignment agreements? Where are the employment agreements? Where are the contractor agreements with the people that are developing your software, that are developing your products, that are developing, your website? Where are the contracts? And the companies say, well, we didn't want to spend money on lawyers, blah. Well, what that means very often is that the company itself doesn't even own the intellectual property that's been paid for. Whether it's technology that's developed that may be patented later on, whether it's copyrighted material, whether it's know-how, all kinds of intellectual property that's developed, if it's not reduced to some kind of a written agreement that the company owns it, by law, in a lot of cases, the company's not going to own it, and that's going to immediately preclude any investors from coming in and saying, I want to invest in you, because they can't be 100% certain that the person who developed your software isn't going to go and start up a competing company and will rightfully be allowed to do that because you didn't have a written agreement to commit that intellectual property to be assigned to the company. Critical. Then there's board and shareholder resolutions that are just approving the transaction, and then some certificates where the officers, which are the key executives of the company, agree that they'll comply with certain terms and conditions. They make certain representations, like the IP is owned by the company, like they're the only employees, that all the employees have signed agreements. All those kinds of representations and warranties are done personally by the officers, as well as by the company in the purchase agreement. Okay, I thought it would be interesting for you to see what, in terms of a timeline, and this is an ideal situation. It varies from every deal, but just to give you a sense of what a timeline looks like. You've got a term sheet, figure 2 to 4 weeks if everyone's serious and you can get through the sticky points, it's signed. Okay, the transaction documents are going to be provided. They're going to be negotiated. Figure, from 30 to 60 days, you're going to have a closing. So it can move, within the 3-month period, like you had asked before about the lockup. If all things go well, 3 months should be plenty of time to do a deal. Again, lots of variables, and it could change. Okay, I'm going to hit the top 5 critical deal terms. We're actually, how much time do we have?
Not much, 4 minutes.
4 minutes, we're not going to make it, but we'll try to run through it quickly. Okay. You've heard already from me that there's a lot of complexity in these terms. If you've never done a deal before, you definitely need, legal counsel. You must, because it's so complex if you've never done it before that you could make mistakes by not appreciating the relevance or significance of certain terms and requirements. You want the money, you want to sell the equity to the investors, but you don't want to give away your company. You don't want to sign things that you didn't realize that you were giving up, control, decision-making authority, things like that. Okay, we're going to hit the top 5. The first one is reverse vesting of stock. And what that means is very often you may be the owner of your company today, but once the investors come in, they may say, okay, you own the company today, but if you are fired from the company, because you can be, if you do something wrong, if the board of directors, which will be probably controlled or very strongly kind of held by the venture capital investors, you do something wrong, they fire you, they don't want you to take your stock with you. Okay, so there's going to be a vesting period that even though you start off owning it, once they come in, they're going to say, okay, if you're still here after a year, you get to keep this much. If you're still here after 2 years, you get to keep this much. If you're still here after 3 years, you get to keep, another bunch. Okay? Business owners hate that, but venture capital funds want to know that you're going to be there, and they don't want you to walk away with equity if you do something wrong, things don't work out, because they need that equity there to give to the next CEO or the next senior executives. Funding model. Very often you see that venture capital funds will invest either the full amount on a closing, or they'll condition payments. They'll give you part payments. They'll say there'll be 4 milestones that we want to see if you can develop your technology, meet certain technological thresholds, and you'll get money. We want to see you file a patent application. You'll get some money if you do that. We want to see some sales. You'll get some more money if you do that. So a lot of times if you hear that these $50 million venture deal was closed or the $20 million venture deal was closed, a lot of times only $5 million is actually going to the company at that moment. But it's creating the base and the opportunity for the companies to hit those milestones. They have money, they can hire employees, they can buy supplies and everything they need to hit the milestones. Okay, there's sometimes technological achievements, beta testing, all different kinds of things that, again, let the venture capitalists control how their money is being spent. Top critical term number 3 is a liquidation preference, which is the heart of a venture capitalist's investment. And you may have heard the term, you may not have heard the term, but a preference allows a venture capitalist on an exit to get their money back and to get some kind of a premium on top of their money that they've invested. Okay, I think I'd be happy to talk to anyone offline. I need a little bit more than 2 minutes to describe it, but typically in a liquidation preference scenario, if there's an exit, and when we say exit, it's a merger acquisition of your company, okay, or an IPO, an initial public offering of your company. The venture capital fund wants to make sure when there's a sale of stock that whatever money comes in from the sale, they get all their money back, plus some kind of a dividend, and often it's a multiple. It may be 2 times what they've invested or 3 times what they've invested before you get any money from that exit, okay? And then they'll also share from whatever's left over after their preference. Redemption rights is another part of a liquidation preference, and that is that after a certain period of time, if the company's not going anywhere, if it's not growing at the speed at which the venture capital fund wanted to see growth, they have a right typically between 5 years from the closing of the investment to 7 years. They could say, you know what, we want out. We want you to buy back our stock and with a dividend. And so they force a buyback. It's a redemption. They say, here's our stock, pay us what we invested, plus our dividend, plus there may be some other things that come out of it. So these are key. Liquidation preference and redemption, key terms for venture capitalists. 4th, we're almost there, Kenya. Board composition.
We're moving over here, right?
Board composition and protected provisions. Again, how many board members are there going to be? Who are they going to be? What are the rights? Do they have veto rights? Typically, there's a long list, and it's in the term sheet, and it's in the Investors' Rights Agreement and the amended and restated Certificate of Incorporation. It says you can't spend more than, let's say, $20,000 without board approval. You can't change the agreed budget or business plan without board approval. You can't hire certain types of, levels of executives or pay certain salaries without board approval. You definitely can't issue any more stock of any kind without board approval. There's a lot of control mechanisms in there, again, to make sure that what the venture capitalist investors invest in is theirs and no one's taking it away from them. Okay? Also, very often, we're talking about all these controls. The good venture capital funds have professional executives who've been with many, many companies over many, many years, and they help a lot. So there are some funds that actually the directors would like to be involved with the day-to-day operations in some way or week to week. And sometimes it's often extremely helpful and beneficial for the company. And in this presentation, there's a list of these veto provisions. Finally, the 5th top critical deal term is conversion and anti-dilution protection. And that also addresses a situation of an exit event where, in most cases, the venture capital investors are holding preferred equity in your company. Typically, the founders are holding common equity. And the preferred equity carries all these special rights to sit on the board, to be able to veto, to be able to force the entrepreneurs to sell their stock if there's some kind of an exit. All kinds of provisions are tied to the preferred stock. But when there's an IPO or even an acquisition, there's a conversion. The preferred stock is converted sometimes automatically, sometimes by right. It's converted from preferred stock to common stock, so that the whole company's equity outstanding is common. Okay, and there's ways to conduct the conversion so that the preferred shareholders can continue to have beneficial rights on the holdings. At the same time, if there's additional issuances, the venture capital funds want to make sure that they can maintain their capitalization in the company. So there's something called anti-dilution protection. And it helps, again, to ensure that the investment is made so that their percentage holdings in the company are maintained, even if they decide for some reason they may not want to invest. I've got 2 bonus points. This is very important, Ken, you have to admit. Okay.
I have something very important to share too.
Okay. The lawyer's role in venture deals is to help translate these complex items so that you can understand them, to push the deal forward, to help as a bridge between the venture capitalist and the entrepreneur, and help the deal go smoothly and help build that relationship. And that's it. This is a summary.
Shared line.
Thank you very much.